I genuinely thought that this next video was going to be on an area of law other than defamation. Alas, the Defence Minister, Peter Dutton, has decided to start proceedings against a bunch of people on Twitter, raising a few rather good defamation law issues. Can you sue people for their spicy takes on Twitter? Spoiler alert, yes. Can you be sued if you're just repeating what somebody else has said? Spoiler alert, yes. So rather than waiting for you to get info on your own, I'm going to deliver it. Knock knock, open up the door, it's real. So let's get up to speed on the Dutton issue. The minister said some indelicate things about the Christian Porter matter. A Green Senator, Larissa Waters, published a media release that called Minister Dutton an inhuman, sexist rape apologist. Senator Waters retracted the statement and made an apology to Minister Dutton. But, in response to Senator Waters' comments about Minister Dutton, a bunch of people on Twitter, the forum of choice for reasonable, balanced, dispassionate political debate, went absolutely batshit. In one key aspect, this has an interesting relationship to another defamation case from a few years ago. This is Osman Faruqi, the son of Green Senator Dr. Marine Faruqi. Osman Faruqi is notable for having mostly a stream of just absolutely terrible opinions on social media, but inexplicably, Mark Latham, former federal leader of the Australian Labor Party, decided that Faruqi was also an advocate for terrorism. It was just a manifestly absurd thing for Latham to claim, and it resulted in Faruqi receiving a lot of unwanted, mostly racist, attention from the swamps of the internet. Faruqi made the rather sensible decision to sue Latham for defamation. This entirely sensible decision had two outcomes. First, it resulted in the most incredibly, amazingly, insane pleadings from Latham. Justice Wigney of the federal court wrote an incredible judgment, basically telling Latham to put his defence in the shredder and start again. Here is the opening of Wigney's judgment. What does the martyrdom of Christians in the Roman Empire between the reign of Emperor Nero Claudius Caesar Augustus Germanicus and Emperor Flavius Valerius Aurelius Constantinus Augustus have to do with the defamation action commenced in Australia in 2017? How could the persecution of ethno-religious Huguenots in the French kingdom during the French Wars of Religion during the 16th century be said to rationally affect the assessment of the probability of a fact in issue in a modern-day defamation action in which the defamatory imputations are said to be that the applicant knowingly assists terrorist fanatics who want to kill innocent people in Australia, and so on and so on and so on? It is amazing. Check it out. Get it into your veins. The second, and frankly far less fun, outcome was a lot of noise from various commentators that Osman Faruqi should simply tolerate being called an advocate for terrorism. This is Paul Barry, the current host of ABC's Media Watch. On 20th November 2017, Barry described the case as a legal cockfight between two loudmouths. Now remember, Latham accused Faruqi of aiding and abetting terrorism, and Barry thought that suing Latham for these comments was unreasonable, describing it as, quote, lawfare. In a case with so much absurdity from old white guys, I probably shouldn't be as surprised at the following quote from Barry as I am, but here we go. Commentators like Faruqi, who dish it out, should surely be able to cop a little bit of flack in return. A little bit of flack? Latham accused Faruqi, a Pakistani Australian who regularly cops racist abuse from a range of sources, of being an advocate for terrorism, and Paul Barry thinks that this is just a little bit of flack. In which consequence-free paradise does Paul Barry live, and can I please move there? But Anyway, it gets me rather neatly to the Minister Dutton issue. Whatever you think of the guy, and I don't think much of him at all, under what circumstances should a person have to tolerate falsely being accused of being a rape apologist? As I said in previous videos, do we really want to live in a society where it's on like Donkey Kong if the target is a politician or public figure? Now, what is unusual here is that the target of Minister Dutton's legal threats are complete randoms on Twitter. They're not journalists. They're not other politicians. They're not public figures. They're complete randoms. Now, recall the three elements of the cause of action in defamation law. First, there is the communication of defamatory matter. Second, the communicated defamatory matter identifies the person suing. Third, the defamatory matter was communicated to a person other than the person suing. If you have these three elements, you have the cause of action in defamation law. Now, once upon a time, there was a difference in Australian law between two species of defamation: libel for permanent communications like writing, and slander for impermanent communications like speech. Australian law no longer uses these concepts, but the differences between them were once quite significant. One of the differences was the presumption of damage. If something was written down, said Lord Justice Bowen in the English case of Ratcliffe and Evans, every libel is of itself a wrong in regard to which the law implies general damage. But if a disparaging comment was spoken, it was only actionable per se if it conveyed one of a list of very specific meanings. One, that the person had committed a crime, that they had a contagious or infectious disease, that they were crap at their job, or, in the case of women, that they were unchaste or adulterous. Social media has done something rather interesting to the relationship between spoken word and written word. Ratcliffe and Evans was a case from the 1800s. If you're going to write something down, you were setting aside some time in order to deliberately write it down. They were your considered thoughts. Now, with Twitter and Facebook, we can trash talk on the fly without giving it all that much thought. A lot of our written text looks a lot like our spoken word. Side note, one of the reasons I'm interested in this distinction between speech and writing is that this is the same dichotomy that shows up in communications interception law. But back to the main game. What are our intuitions about trash talk on social media? There seems to be a bit of a balance here. On the one hand, it's social media, where people have wildly spicy, unhinged hot takes. But, on the other hand, these people are saying really horrible stuff about a public figure. Before we shift on to the next bit, it's worth thinking about how we think the law should balance these things. It has to be somewhere between a laissez-faire Wild West scenario where lawlessness reigns and a strict expectation that every person who signs up for a Twitter account will also commit to discourse of the highest standards. Australian defamation law has a bit of a crack at this problem. Section 33 of the Uniform Law provides for a defence of triviality, but it's important to get the words right. It is a defence to the publication of defamatory matter if the defendant proves that the circumstances of publication were such that the plaintiff was unlikely to sustain any harm. The circumstances of publication is interesting because it means that we are talking about a defence in defamation law that has no direct link to the imputation. It's not that the imputation was trivial, it's that the circumstances of publication were trivial. And this is one of the reasons why the defence is not well understood. Media cases with heavy-hitting defamation barristers are never going to involve a situation where the circumstances of publication were trivial. Let's take an example. This is Oscar the Grouch. He lives in a trash can on Sesame Street, and he has some wildly defamatory opinions about Big Bird. On the side of his trash can, Oscar puts up a sign that reads, "Big Bird murdered Mr. Hooper." This is an extremely defamatory thing to say, and it's an extremely serious allegation. So Big Bird decides to sue. And Oscar the Grouch completely freaks out. He's a notorious drunk and can barely remember writing the sign. And he's looking at the concerns notice that he's received and he's like, what on earth do I do? The letter of the week is threatening court action. Fortunately for him, She-Hulk hears about his case and decides to represent him. And she says, look at the circumstances of the publication. It was a sign on a trash can. Not that many people saw it, and those who did see it knew it was from notorious arsehole Oscar the Grouch and simply didn't believe it. The circumstances of the publication were that Big Bird was unlikely to sustain any harm. Now, it's a completely different story if serious news journalist Kermit the Frog says on nationwide news that Big Bird killed Mr. Hooper. The circumstances of the publication are different. Thousands of people see it. Many are likely to believe it. The circumstances are likely to cause harm. Now, this is deeply legally weird, and the defense has an interesting history. Not only is it a defense that does not go to the imputation, after all, we're talking about the circumstance of the publication and not whether or not it's true or anything, but look at these words carefully. Remember back in the previous section where I was talking about libel and the view that every libel was an actionable wrong where the law implies general damage? Now, there's a bit of a slogan in defamation law. Defamation law presumes harm. If you like swirling cognac in a big glass, you say that there is a presumption of damage. But the triviality defense says, hang on, yes, we assume the presumption of damage, but let's be serious. There are some publications that are just trivial. Let's have some nuance. So where does Twitter fit into all of this? Is it more like Kermit the Frog, or is it more like Oscar the Grouch? Does it depend on whose Twitter account it is? Well, these are questions for a judge. There are some Twitter defamation law cases, the most prominent of which unfortunately involve very prominent persons. And the cases that should have been the most helpful, unfortunately, were not high end of town stuff, but disputes between ordinary people over petty arguments on Facebook, which means you don't really get good, beefy case law. One of the most highly cited cases here was a situation where the defendant simply did not show up to court, and this really limits the development of the case law. Big cases involving Twitter: Joe Hockey and Fairfax. Fairfax published a story, Treasurer for Sale, and then pointed to the story on Twitter. So not a pure Twitter case. Crosby and Kelly was a pure Twitter case, as far as I know, but it settled, which is boring as hell, despite being good legal practice. The largest pure Twitter case that I can find was from the UK. Here is Lord McAlpine and Sally Bercow. McAlpine was a conservative British politician during the Thatcher years as a member of the House of Lords. Sally Bercow is the wife of the Speaker of the House, John Bercow. Former Speaker, sorry. Wikipedia describes her as a personality. So what happened? BBC Newsnight ran a story claiming that a senior Conservative politician was involved in historic sex crimes. They did not name the politician, but lots of people on Twitter thought that they knew exactly who it was, and they named Lord McAlpine. So Lord McAlpine issued legal letters to about 500 people on Twitter, settling nearly all of the cases. But Bercow did something a little bit different. Here is her tweet. Okay, so there are some differences between Australian and UK defamation law, but one of the interesting things here is whether this tweet actually does convey defamatory meaning. It very clearly identifies Lord McAlpine, but does it convey the defamatory meaning? The court said yes. The judgment by Justice Tugendhat said that this tweet provided the final piece in the puzzle for readers to connect the Newsnight story with McAlpine. It's a decision which, in my view, largely turns on its own facts. But it's a pure Twitter case in the sense that the publication was only a tweet. Final bit on triviality. It is not long for this world. Australia is getting amended defamation laws rolled out across the country. One of the amendments is the introduction of a serious harm threshold, Section 10A, that will make serious harm an element of the cause of defamation. So you'll need to prove the usual three elements and this new element about serious harm. The person alleging defamation will need to prove that the publication of defamatory matter about a person has caused, or is likely to cause, serious harm to the reputation of the person. Unfortunately, the provision is then followed by a nightmare amount of subclauses about how the element is supposed to work, but this is it in a nutshell. As a consequence of this, the triviality defence is being abolished. Sidebar, I think that abolishing the triviality defence here is wrong. Remember that the defence was about the circumstances of the publication. This is an issue about what the person did at a point in time. Oscar the Grouch, at that point in time, published in a way that was unlikely to cause harm to Big Bird. The new test is slightly but significantly different. Previously, Oscar could have said that the circumstances were unlikely to cause harm, even if they did cause harm. Now, if Big Bird slips over the line by showing that Oscar did cause some harm, Oscar cannot say that, at the time of publication, the publication was not likely to cause harm. It's actually narrowed the defence for Oscar on that front. Back to Minister Dutton for the final stretch. He's gone after a handful of people on Twitter for comments that seem to have originated with Senator Waters. Can't people on Twitter just say, hang on, it wasn't us who harmed Minister Dutton's reputation, it was Senator Waters, and we just repeated it? There are two sides to republication. One side is liability of the original publisher if somebody republishes defamatory material. Quick example. Bert says something defamatory and Ernie repeats it. There are scenarios in which Bert is liable for Ernie's publication. The big case on this was from the 1800s called Spate and Gosnell. It's fairly commonsensical. Bert here will be liable for Ernie's publication if Bert requested or authorised the republication, if Bert intended that Ernie should republish, here's the wild one, that Ernie's repetition was the likely or natural consequence of Bert telling Ernie, or that there was a duty or obligation on Ernie to repeat the defamatory comment. Depending on how vola and nationwide news goes, I might do a video that digs into this a little bit deeper. But then there's the other side of republication. To what extent does each repetition of defamatory matter constitute a new cause of action? Now, the strict rule is that every publication is a new cause of action. If Bert says something defamatory and Ernie says something defamatory, the default position is that they are both liable for their publications. And as we saw with Oscar the Grouch and Kermit, they might have very different defences for saying the exact same thing. And so, on Twitter, the default position is that if you repeat something defamatory, you are a publisher of defamatory matter and need a defence. Now, I keep saying default position here because there are some exceptions, or rather defences. One of these is innocent dissemination. You're definitely a republisher of the defamatory material, but you did not know that the material contained defamatory matter, you did not know that the material was likely to contain the defamatory matter, and your lack of knowledge was not a result of negligence. This is the common law defence. The statutory defence of innocent dissemination throws a little bit of a wild card into this mix. The statutory defence has three elements. First, that you're a subordinate distributor. Second, that you didn't know and weren't reasonably supposed to know that it contained the defamatory material. And third, that you weren't negligent in your lack of knowledge. So what's a subordinate distributor? The Act provides a list. Sorry about that. Librarians, booksellers, newsagents, providers of postal services, broadcasters who do not control the content, so forth and so forth. Unfortunately, not obviously relevant to people talking smack on Twitter. So the takeaway message here is that when you tweet something spicy, you need a defense. And the defense cannot simply be, I was just repeating somebody else's spicy take. Well, not simply, at least. But that is it for this one. I'm getting lots of great feedback, so much so that the feedback has now started to contradict other bits of feedback. But if you want to chat further, I'm on Twitter @LegalReckoning. Bye-bye.